A true welcome is never complete without warm words and warmer gestures. It is an honor to have Mr. Ellen Mishra, sir, here with us today. I request Honorable Mr. Justice Bhava Singh, sir, to welcome our chief guest with a planter.
Let us now look at a brief video montage capturing the vibrant spirit and legacy of DME Legal Aid Cell, DME Law School. I request the IT management team to kindly play the montage for us.
Now to welcome our chief guest and the students, I invite Professor Dr. Rajinder Kaur Randhawa ma'am, DME HOD Law School, to kindly address the gathering.
Thank you, Susanna. Our worthy chief guest for today, Shri Lakshmi Narayan Mishra ji, our Honorable Director General Sir, Justice Bhavar Singh, our officiating Director Ma'am, Co-Professor Komal Vich, Neha Ma'am, convener of today's event, Anand Sir, convener for today's event. It is a matter of pride as well as of joy to welcome you all to this August gathering. So to introduce DME, we are working on and flourishing under the aegis of Sunshine Educational and Development Society. Here at DME, we are imparting education to around 3,000 students in the fields of management, media, and law. And under law, we are running the courses of BALLB, BBLLB, and master's program in the streams of ADR and corporate laws. Here at DME, our vision is to ensure the holistic development of our students. and our teachers, our faculty members, they are experts of their subjects. They are the architects, and with chief architect, our Director General Sir, Justice Bhavar Singh. He is always guiding us, mentoring us, how we can excel and how we can work towards the future of the young generations, which are the coming future legal practitioners, scholars, and jurists. And I am happy to share that we are also having multiple societies working in DME Law School, like Moot Court Society, Legal Aid Cell, Research Cell, and there are so many other committees which are working towards the skill, providing our students with the skill set which is required today, not only academics, but the students need to have that skill set, which is certainly required for the rapidly changing world. With that in mind, that thought in mind, today our legal aid cell, which is very vibrant cell, always active in organizing some awareness sessions at various places in some NGOs, some schools, with the imparting the POSCO training or POSH training to the concerned people. And today we have come up with this idea of checking and analyzing the uh, working of new criminal laws. So it's been a year now after the implementation of new criminal laws, which replaced the century-old laws. Uh, Indian Evidence Act gave way to Bharatiya Nyaya Sanhita, Criminal Procedure Code gave way to our Bharatiya Nagrik Suraksha Sanhita, and Evidence Act, which gave way to Bharatiya Sakshi Adhiniyam. So this is a very good initiative by Legal Aid Society, and I wish the very best. And today we will be having the panel discussions after the inaugural ceremony to have the dialogue that will be very fruitful and enriching. And I hope you will have that learning and the outcome with you today, which is very, very required to understand what are the new laws and how they are implementing and how they are beneficial and in delivering the justice system. Thank you so much, and welcome signatories once again. Welcome you all. Thank you very much.
Thank you, ma'am, for your warm words.
Now, we are very honored to have with us Professor Dr. Komal Vig, ma'am, Officiating Director, DME, here with us today. Ma'am has extensive experience in the field of law and legal education. She has made significant contributions while working with various esteemed universities such as Amity University, Dean School of Law, Sharda University, and Dean Institute of Legal Studies, Chandigarh University. I now request ma'am to please address the audience.
Honorable Mr. Justice Bhavar Singh Ji, Director General DME and former Judge, Allahabad High Court. Our very esteemed Mr. Ellen Mishra Ji, Legal Advisor, Bureau of Civil Aviation Security, DIG retired, Law, CRPF. My dear colleague, Dr. Randhawa, Dr. Neha Behel, and all the respected teachers present here, and most endearing students, a very good morning to all of you. Today we are gathered here to witness a very important event, a national seminar on 1 year of new criminal laws, strengthening legal aid for equitable access to justice. We all know that these 3 new laws were enforced, that came into force on 1st of July 2024, and now 1 year is over. We are here to access, as per our understanding, that what are the challenges which are there to implement these laws with full spirit, in whole heart and spirit. So, this seminar is basically designed to give you the insights of the academic excellence, academic transformation, as well as what are the practical challenges which are faced by the courts as well as the advocates in enforcing these laws. So basically, I believe that today's all sessions will be a great learning for you. As far as the title is concerned, when we were discussing about what should be the title, we decided the word to incorporate the word equitable access to justice. Everyone asks, what was the requirement of having three new criminal laws? And it is generally said it is the old wine in the new bottle, because most of the sections are same. Most of the provisions in all the three laws are same, of course. But the requirement was that we need to get away from the shadow of that colonialism. Of course, I was discussing with our esteemed guest that Lord Macaulay, who gave us IPC, the most important criminal law, the substantive criminal law, he was a learned man. And he was the man who brought a revolution in the criminal justice system by codifying the law. And now it is required, as you have seen, there are a lot of changes and transformations, and I must say, unfortunate developments in the types of crime and the ways of commission of the crime. So in order to curb those, there was a requirement of major and drastic changes in the criminal laws of the country. Laws, as Sir said, that laws should be evolving. Unless and until we are evolving, we are transforming the laws according to the changing needs of the society, law will absolutely fail in its purpose. So that was the major requirement that the three criminal laws were brought in. And majorly, the main features were to make criminal justice affordable, accessible, approachable, simple, consistent, and transparent. From the name here, you can recognize, otherwise, it was Indian Penal Code. And now it is Bharatiya Nyaya Sanhita. That means now you can understand the psyche behind it. Earlier, it was enacted by the British people specifically to punish the Indian who were committing crime against the British regime. So these laws were enacted for that purpose. But now we are a sovereign country. We need nyaya to be delivered, justice to be delivered. That's why it is renamed as Bharatiya Nyaya Sanhita. Of course, it is penal in nature. Whosoever will commit a wrong will be penalized for that. But the main purpose is to deliver justice. Second important thing, recently, I believe a couple of months ago, our Honorable Home Minister, Mr. Amit Shahji, he spoke about the 1 year's achievement or understanding of these three criminal laws. And he has very well mentioned that it is the golden era of governance, which is rooted in social, economic, and political justice, which was began last year by the Modi government. And of course, we must appreciate the efforts, because please understand that it was not a practice which happened in a day or in an year. This practice started long back from 2018 or 2019. I was associated with other academic organizations, but yes, I still could recall that we received the letters from the Home Ministry at that time that they want to make the changes, and our suggestions, all the stakeholders' suggestions were called for, and after an extensive study of approximate 89 countries of the world, the criminal justice system of the 89 countries, and after incorporating and having suggestions from all the stakeholders of the society, may that be academia, may that be the industry, advocates, judges, police, everyone, whosoever are the parts and parcel of the criminal justice machinery. Their suggestions were taken, and now we have come up with the new 3 criminal laws. Of course, I think the most challenging part is with we people, the teachers, as well as the judges and the advocates who are in practice these days, because we have to unlearn those and relearn. Unlearning is little difficult. Even today, you will witness many your teachers are coming to teach you BNS or BNSS or Bharatiya Sakshya Adhiniyam. They people must be bringing the old barracks along with them, because we were oriented according to the previous laws. But the major advancement which is brought by these 3 laws is, first of all, victim is given importance. Earlier, the criminal laws were main focused on penalizing the person who has committed the wrong. Very well, it should be done. But what about the victim who has suffered? What could he do? He can only go for compensation or damages in the civil law. But here, and moreover, there was no protection of the victim and the witnesses in the previous laws. So certain new provisions have been added into, and the major advancements have been brought in the form of the acceptance of e-evidence, which is very much required, because kind of challenges which are coming up with the new technologies, the development in new technology, and especially I was discussing with sir that we are right now heading towards another, which I must say that is extremely, that could be horrifying in future if AI will start the destructive work, and we have to cope up with that. And for that, I believe the changes in the laws are required from time to time. Forensic evidence has been given a lot importance in these 3 criminal laws, which was much required, because you are the students who will study the new laws, and of course your teachers will be orienting you, inducting you with the previous laws and the shortcomings of the previous laws. Only then you will understand what is the difference and why it was much required. So, of course, you will be learning more about the advancement and the changes which have been brought by the 3 new laws related to terrorism, organized crimes, right from mob lynching and everything, new sections. One thing which I was about to explain you about the equitable justice. Why we have incorporated this word in equitable? We all speak for equality. We all say that there should be equality. What is equity? Equity means to achieve equality, we have to give certain special privileges and we have to make certain provisions for the downtrodden or vulnerable sections of the society. And keeping that in mind, special chapters have been incorporated, heavily casted in favor of women and children to protect them from the crimes against women and children. So whosoever says that it is not equality because the laws are heavily casted in the favor of women, please understand, in order to achieve equality, we need to have the equitable provisions in all the laws as well as the policies of the government. Only then we can bring them in the mainstream and can do the real justice to women and children. With these few laws, my views, I wish that all the sessions will be very fruitful, and I really hope to listen from Honorable Lordship and our respected guest. He can throw more light on the practical aspects of the criminal justice mechanism of the country, and eager to hear to that. With all these words, thank you very much and wish you good luck.
Thank you, ma'am, for your words of encouragement.
Now, moving forward, no institution can run without the presence of a good leader, and we are grateful to have our Director General, Honorable Mr. Justice Bhavar Singh Sir, with us. Sir was appointed in UP Judicial Services in the year 1970 and was promoted to Higher Judicial Services in 1979. He then presided over a special court of CBI Dehradun and was elevated to Registrar Allahabad High Court in the year of 1992, where he worked for about 3 years. Sir then graced the office of Registrar General Supreme Court of India and was elevated to permanent judge of Allahabad High Court in the year of 1999 and held office up till 2007. He was then appointed for 5 years as president of UP State Consumer Commission, thereafter which Sir adorned the office of chairman, Judicial Training and Research Institute, UP from 2012 to 2014, and then joined DME as professor and director general in 2014. I now invite Sir to kindly address the gathering and share his valuable thoughts with us.
Mr. Lakshmi Narayan Mishra, a very pious name, former DIG and also legal advisor to Civil Aviation Department. The officiating director of DME, Dr. Komal Vij, HOD of Law, Dr. Randhawa, coordinator of the team, Dr. Neha Behel, Mr. Anand, assistant professor, their faculty members, dear students, participants, ladies and gentlemen, it's really a good topic to be discussed, particularly for a man like me who dealt throughout my 44 years of career in judiciary, the Indian Penal Code, the Indian Evidence Act, and the Criminal Procedure Code of 1973. Also, I had decided some cases under the Criminal Procedure Code which was in force before 1973. There have been very striking changes in all the three acts. And really they will serve the cause of justice. Also the interest of victims, as Dr. Komal which said. And the general public at large. I'll confine to, during my interaction with you, the topic of life imprisonment, about which there was an utter confusion prior to Bharat Nyaya Sanhita. It was considered that life imprisonment means 14 years. It was also referred to as 20 years, unless remitted earlier. In jail manual also it was considered to be as 40 years, 14 years. And even the Supreme Court of India, as well as the High Courts, they had various views on the point. Way back when Vinayak Godse's case was decided, it was said that life imprisonment means jail term for remainder of the life of the accused, of course. But it was rarely followed, and the court were handicapped not to give any description of life imprisonment except about the sentence of life imprisonment. Rest to be interpreted by the authorities. And there was a general rule of all the governments, including the central government, that soon after 14 years, a remission was granted. It was almost a rule. The behavior of the convict inside the jail was also one of the greatest factors to be considered. And the power of clemency or reducing the sentence or remission, they were considered to be the privileges of the governments. I remember one case, and many of you might have gone through it, Dr. Nanavati's case. Nanavati was a naval officer. He was convicted for killing his wife's unethical friend and awarded life imprisonment. The appeal was filed by him in the Supreme Court, and during the pendency of the appeal, the then President of India granted clemency. The Supreme Court felt offended and quashed the order of clemency of the President of India by holding that unless the appeal is finally decided, the power of clemency or granting remission does not invest in the President or the governors, as the case may be. And the life imprisonment of Nanavati was confirmed. But since he was considered to be very close to the government circles, after 3 years being in jail, he was released on pardon being granted by the governor of the state of Bombay, as it was then. Subsequently, the state of Maharashtra and Gujarat came into being. So, what resulted after the governments very frequently exercised this power of clemency and remission, that the Supreme Court at times where the very heinous and ghastly acts were committed, the Supreme Court and the High Court started passing orders that the accused who has been transported to life imprisonment shall remain in jail, throughout the remainder of his life, and the government will have no power to grant pardon, clemency or remission to him. This again created some hardships in some cases. Now the entire controversy has been set at rest by the new act called Bharat Nyaya Sanhita. It has really given a mental consolation to the judicial circles. When heinous offenses like brutal murders, gang rapes were committed, the court had their limitation to award life imprisonment. But now, the provisions of Section 64, Section 65, that is rape on a minor below 12. Then rape on a victim in vegetative state. Then section 70, gang rape, and section 71, where this ghastly act is committed repeatedly. In all these sections, it has been specifically and mandatorily provided that life imprisonment would mean the natural life, the remaining natural life of the convict, that is the rest of the life or remainder of the life. It has been clarified again and again so that the courts may not be under any confusion, and the government must also take care while granting clemency. And the Supreme Court and some of the high courts have even gone to the extent that the government will have no power to grant clemency in a particular case. So friends, there have been many changes in all the three acts, that is Bharatiya Nyaya Sanhita, Bharatiya Saksh Adhiniyam, and Bharatiya Nagrik Suraksha Sanhita. I believe that almost all the changes will be discussed during the course of the day, and you must be benefited by the knowledge that will be shared with you by some of our experts. I wish this conference a great success. I wish also that a great learning must be showered upon you all who are participating in it. Thank you very much.
Thank you very much, sir, for your inspiring words and blessings. Today, we are truly honored to welcome Sri Lakshmi Narayan Mishra, sir, a distinguished officer who has dedicated over 3.5 decades of service to the nation in CRPF, RAF, NSG, and even in UN peacekeeping missions. With an illustrious career marked by leadership in counterinsurgents operations, legal expertise as additional judge, Attorney General at NSG, and a wealth of academic achievements, including LLM, MBA, and specialized certification in law and human rights. Mishra sir embodies the spirit of discipline, dedication, and excellence. Currently serving as a consultant law officer in the Bureau of Civil Aviation Security, he continues to contribute his knowledge and experience to strengthening India's security and legal framework. We are privileged to have him with us today. I now invite sir to address the audience.
Thank you very much. Honorable Mr. Justice Power Singh, Director General DME, Professor Kamal Viz, Professor Rajinder Kaur Randhawa, Professor Neha Bahl, students, my dear friends, ladies and gentlemen. I am basically a police officer, not academicians like professors and professors in the universities and colleges and lawyers in the courts or judges who have in-depth knowledge of law rules, regulations, and procedures. Being a law enforcer, as a CRPF officer, as a police officer, we have been implementing the general laws like IPC and other laws, besides special laws which were applicable in the terrorist infested areas or insurgency infested areas, also in Naxal areas in Chhattisgarh and Jharkhand places. Today, I am honored. It is my privilege and responsibility to stand before you today at this national seminar on 1 year of India's new criminal laws, strengthening legal aid for equitable access to justice. This is in fact a very relevant subject which is connected to the people at large. I am not here just to speak on this subject and to deliver lecture. I am here to inspire these youngsters, young students, and I am here to take a resolve that we will enforce law in such a manner, we will extend our legal aid to the people so that everybody is benefited and justice is available to one and all. I'll quote Mahatma Gandhi, who said that justice that is not accessible to the poor is neither justice nor law. This seminar is not just for the statutes, to review the statutes which have been enacted recently, a year back. It is about the people and how we make justice reality for every citizen of the country. Change is the law of nature. There is nothing permanent in this universe except the change. Evolution is a continuous process. Once we refuse to change, we are bound to decay and we are bound to become obsolete. In this process of evolution, the old colonial major acts, IPC, CRPC, and Indian Evidence Act, they have been deleted and transformed into new acts like Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita, and Bharatiya Saksh Adhiniyam. The aim, what was pronounced by the government in the parliament itself, the aim was to decolonize, simplify, modernize, and above all to make the system more victim-centric and citizen-friendly. But after completion of more than a year now, we must assess and we must ask, has this transformation touched the lives of ordinary people? Have these laws made justice more accessible to the common citizen? Because laws on paper matter little unless they bring justice to the doorstep of the common man. Because justice delayed is justice denied, and justice denied to the poor is no justice at all. Our constitution makers, they made various provisions related to the fundamental rights of the citizens of the country. Part 3 of the constitution deals with that. There was no provision for legal aid as such, but Article 19, right to life, which has been later on interpreted by the courts as a right to life means right to live with dignity, right to live, right to follow the procedure, right of information, right to information to the people. These all rights have been included in that, and later on Supreme Court has interpreted it interpreted it in that manner. In the 42nd Amendment of the Constitution, which is also known as mini Constitution in 1976-77, when the emergency was going on, this Article 39A was incorporated in the directives of state policy, and wherein the state was made to provide free legal aid so that justice is not denied because of the poverty or disadvantage to a victim. After that, there was a case, famous case, Husainara Khatun versus State of Bihar in 1979. In that case, a PIL was filed, News Justice P.N. Bhagauti was there, and I think this was the turning point in the history of the criminal justice system, where PIL had been given this much importance, and this is one of the most important PIL filed in the courts. In that case, it was revealed the shocking plight of under trial prisoners languishing in jails for years without trial, without bail. Many victims had undergone the judicial custody more than the maximum punishment was prescribed for the particular offense for which they were being held in custody. The court declared that legal aid is a fundamental right under Article 19 of the Constitution of India, and most of the prisoners were released by the direction of the Supreme Court. That landmark judgment led to the creation of stronger legal services authorities, ensuring that the poorest accused had voice in court. Legal Service Authority Act 1987 came into existence, which established NALSA, National Legal Services Authority, and at state level and district level, SALSA and TALSA also, to provide free and competent legal aid to vulnerable and marginalized sections of the society. It organizes Lok Adalats for speedy trial of the cases. It promotes legal literacy and awareness, particularly in rural and marginalized society. Initiates social justice litigation on issues like consumer rights, protection of consumer rights, and environmental protections. Legal aid, therefore, is not a charity. It is justice in action. It is the bridge between the law in books and justice in practice. It takes some time to accommodate to the changes, to accommodate and to assimilate the changes in the system. Many changes have been brought in. These three acts, like Bharatiya Nyaya Sanhita, criminalizes mob lynching, organized crime, and expands protection for women and children. Special chapters have been made in that pertaining to the offenses related to women and children. Victims now have greater recognitions, but navigating the system still requires professional help. So far as Bharatiya Nagrik Sanhita, Suraksha Sanhita is concerned, it requires investigations to be completed within set timelines, introduces videography of searches, and promotes electronic communications of FIR. These measures are powerful, but only if citizens know their rights and have lawyers to enforce them. Bharatiya Sakshya Adhiniyam recognizes electronic records, emails, and digital evidence, but unless legal aid lawyers are trained in technology, the poor risk being left behind is there. I may mention the Shreya Singhal case in which the Supreme Court struck down the Section 66A of the IT Act for violating free speech. It showed how digital rights intersect with the criminal law. Today, with Bharatiya Sakshya Adhiniyam, technology is even more central, making tech-savvy legal aid a necessity. We must acknowledge that there are many challenges before us. There are many gaps in the society. This gap is related to the awareness. Many areas are still in the country and many people are there who have no access to the school and to the education system. And you know the complexity of the complication of the law. Even the well-versed people, graduates and postgraduates, they do not understand law. What to say of the remote areas in Chhattisgarh where I have served, I have seen people do not know anything. They are not concerned with law at all. They are just fighting for their day-to-day life, livelihood, doing something. Still barter system is there in Chhattisgarh. They will take some item which is available in the forest, in the jungle, mahua or some sort of this thing, and they will take potatoes from the other shop. They don't have money, but they exchange their goods for their livelihood. There is a quality gap because society has advanced and legal aid counsels are often poorly paid and they like training in specialized subjects like cyber crimes and forensic laws. There is a urban-rural divide also. The legal aid which is available in Delhi and Mumbai metropolitan cities is not available in the other part of the countries, in rural areas. There is a victim neglect. People are not concerned with the victim. Nobody supports the victim. They leave the victim at their own. There is a technology divide. Poor risk exclusion is an increasingly digital justice system. A very large population who do not have access to mobile towers, internet connections, Wi-Fi, and even the computer, mobile phone, and other technological devices. Now, what should we do to strengthen this legal aid? One, we have to expand the legal literacy. This program what we are doing, this is for that purpose only. This is expanding legal literacy, nationwide awareness campaigns in local languages, use of schools, panchayat, and digital media to inform people of their rights. Second, capacity building of legal aid lawyers. The lawyers should be trained, they should be paid sufficient amount so that it attracts them to work for the victim, for the poor people. Victim-centric legal aid. Dedicated victim support cells under legal services authorities must be established. Witness protection. As seen in many cases where witnesses are threatened and sometimes they are killed so that evidence is not available in the court against the people, against the offenders. Then comes technology as an enabler. Helplines, mobile apps, and AI-based support system for instant legal advice has become a necessity of the day. And we should make a provision so that it is accessible to everybody. Last but not least, the community participation. No program can be successful unless until there is a people's participation, public participation, the NGOs participation, paralegal volunteers and law students as first responders in villages and slums. They should participate. More frequent lok adalats for quick, cost-effective resolution of minor cases must be followed. A test of any legal system is not in how it serves the privileged, but in how it protects the vulnerable and marginalized people. In Nalsa versus Union of India case, the Supreme Court recognized the rights of the transgender community, showing how law can bring dignity to the marginalized people. In Sunil Batra case, the court spoke against the inhuman treatment of prisoners, emphasizing that justice reaches even behind prison walls. Even in Kasab case, Ajmal Kasab case, on 26/11 Mumbai attack, there also Supreme Court appointed amicus curiae, senior advocate Raju Ramchandran, to defend him, who was a known terrorist, who was charged with more than 86 offenses, and he had killed many people. Even then, our judicial system provided him support. Ladies and gentlemen, the new criminal laws represent a turning point in India's legal history. But laws alone cannot deliver justice. The bridge is legal aid. If we strengthen legal aid, train and empower its lawyers, make it victim-centric, harness technology, and involve communities, then and only then will these new laws fulfill their promise. Justice delayed is justice denied, but justice inaccessible is justice undone. Strengthening legal aid is not just a legal reform, it is a democratic responsibility. Together, let us ensure that justice in India is accessible, affordable, and equitable for all. Dr. Ambedkar reminds us that justice has always evoked ideas of equality. At the end, let this seminar mark not only a review of 1 year of new criminal laws, but a reaffirmation of our collective commitment to justice for all, not just for the privileged few. Thank you. Jai Hind.
Thank you, sir, for your valuable insights.
Moving forward, as we are now coming towards the end of the ceremony, I now request Director General Honorable Mr. Justice Bhavar Singh sir to felicitate Mr. Ellen Mishra sir with a memento. I also request our officiating director, Professor Dr. Komal Vig ma'am, to present sir with a token of our appreciation.
To express our collective gratitude to all those who made this day possible, I now invite Professor Dr. Neha Behel ma'am, Faculty Convener, DME Legal Aid Cell, DME Law School, to deliver the vote of thanks.
Respected dignitaries, esteemed guests, faculty members, participants, students, it is my proud moment to deliver the vote of thanks on behalf of the DME Legal Aid Cell, DME Law School, Noida. First and foremost, I extend my heartfelt gratitude to our distinguished guest, Mr. Ellen Mishra sir, for providing his valuable time to the college and to come and address the students and participants. Also for gracing the occasion. Thank you so much, sir. I'm also grateful for providing kind words of wisdom to the participants and the students. Also, very special thanks for our guiding and mentor, Honorable Mr. Justice Bhavar Singh sir, Director General, DME, Thank you so much, sir, for your time and valuable inputs. Every time when we visited you, you guided us. Also, we are deeply grateful to our chairman, Mr. Aman Sani sir, and vice chairperson, ma'am, Nishta Sani ma'am, because their vision was to provide legal aid to the public through DME Legal Aid Cell, and they have truly given us a go-ahead for this national seminar. Also, I am grateful for the valuable moments ma'am has spent with us, Professor Dr. Komal Vig ma'am, officiating director DME, and Professor Dr. Randhawa ma'am, HOD DME Law School. They have always guided us and always motivated us to work for the program. Also, there is our collaborators, DLSA, they have given us a go-ahead and collaborated with us for this national seminar. And our media partners, food partners, thank you so much. And also the students, the core team, okay, the faculty convener, Mr. Anand Singhal sir, he has tirelessly worked with me day and night for, sometimes guiding me, sometimes motivating me to work in the manner. And then the student team, core team students, they have also worked very hard. Then executive members, volunteers, participants, and other students present here. Everybody has contributed for the success of the event. So I am really grateful and thankful to all. And thank you so much. Thank you.
Thank you, Neha ma'am. Thank you, everyone, and we are very grateful to have each and every member in the audience for being a part and making it a success. I now request everyone to please raise for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य